Okay, so we're going to continue with conflict resolution, and we're just going to look at some of the changes to the Individuals with Disabilities Education Act that have occurred in the last reauthorization, in particular, the last one of IDEA. And so it used to be that in terms of remedies, that generally the families could go back 2 years and file a complaint that was perhaps from 3 years, 4 years ago. Now there is a statute of limitations, and so that families in seeking remedies can go back only 2 years unless they believe there was any kind of withholding of information that was intentional. So there are some loopholes in that, but generally we now have a period in time in which to commence legal action. Also, in the latest reauthorization, as a result of a U.S. Supreme Court decision referred to as Schaefer versus Wiest, we have a situation now that the party that is seeking relief has to bear the burden in the case, meaning that, for example, if a family brings the case forward, then they have to bear the burden of proving their case, and that is a change. It used to be no matter who brought the case forward, the district had to bear the burden. And so again, this is the result of the Schaefer versus Wiest Supreme Court decision. So we also get some further defining of parent in the last reauthorization of IDEA, and this is important in terms of conflict resolution because now we know that in terms of however parent is defined, any of these caretakers can bring forward a case. And so a natural, adoptive, or foster parent of a child may serve. So we also include a legal guardian or ward, if the child is a ward of the state. Again, to further define, grandparent, step-parent, or other relative who is legally responsible for the child. And these are all people who are there to protect the right. Again, also a surrogate parent was included. For a surrogate parent, again, these are legal, if they're legally appointed by a judge, if the child is a ward of the state, or if the child is homeless. So these are important things for schools to know, again, who's legally responsible for the child. We have some changes to paperwork and timelines for the due process complaint process, and we have to pay attention to those. Particularly, the hearing officer has to rule whether or not in this paperwork the complaint was sufficient to move forward with a hearing. If the hearing officer rules that the complaint is not sufficient, the parties have 5 days essentially to respond, has 15 days, and then the hearing officer must rule again on the sufficiency of the complaint. There also, in the new reauthorization of the law, has to be a resolution meeting. So again, the whole intent of this is to try to settle the conflict before going to hearing. And in this resolution setting, again, it's not forced, but within 15 days of receiving a parent's complaint, a representative of the local education agency must meet with the parents for this resolution unless both parties decide not to. They're allowed to waive this resolution. So the hearing officer, again, can rule on any procedural violations, but in the new reauthorization, these violations have to meet the level of being substantial, so that they have to rise to the level where they impacted the child's free and appropriate public education. They have to be significant. They have to deprive a child of educational benefits. So again, things like the evaluation taking 2 to 3 days longer might not have denied the child FAPE, but perhaps it would have. Again, that's going to be based on the decision of the hearing officer. So that concludes conflict resolution.